Thank you very much, Jason. You'll notice in Jason's introduction that he indicated that I have no interest, well, I shouldn't say no interest, I have no expertise in the area of tort law, yet that's where I'm speaking at. But I want to thank the Tort Law Research Group at Western for inviting me to give this lecture, and for the Leggett and Associates, the sponsors of the lecture. I think it's much to the stature of Western Law School that it's attracted an extremely talented group of young academics, of which Jason's one, Stephen, Erica, Dennis, Zoe, and that, following in the footsteps of course, the sort of huge leaders in the tort area, Gerald Friedman, Robert Solomon, and Craig Brown. I think it's just amazing that they've got this capacity of tort people, private law people at this august institution. I have to give a disclaimer because by any stretch of the imagination I'm not a tort scholar, and I did offer Jason 3 titles for my lecture, but he chose this one. And it's with some trepidation that I speak, because I'm aware, shall I say, of a certain history at Western that those who speak on or enter the minefield of multiculturalism can end with a sort of career-terminating lecture. Nothing I say will be controversial, I hope, and it certainly won't have the same result. My interest is the extent to which common law principles, in particular principles of damage assessment for personal injuries, are shaped by Canada's commitment to multiculturalism. I started my research in this area in 2006, 2007, and I published an article in the UBC Law Review at that time, and I've subsequently kept up my research and intend to publish another article that comes from this material. Let me give an example of what I mean. In 1997, Ik Sang Lee was involved in a motor vehicle accident that caused traumatic brain injury, leaving him with permanent psychological injury, chronic depression, and other physical injuries, including permanent facial scarring. In his jury trial in 2003, he was aged 23, and the jury awarded him $3 million, $1 million in pecuniary loss and $2 million for non-pecuniary loss. The latter figure was then cut down by the trial judge to the cap of $294,000 at the time, and that issue was taken on appeal. Ultimately, the Court of Appeal did not lower the award. However, in both courts, there was specific reference made to the evidence provided by the plaintiff himself that as a member of the Korean community, facial disfigurement brought shame and embarrassment to him and his family. Clearly, the extent of the plaintiff's injury justified a high award of non-pecuniary damages. But what do we make of that cultural aspect of the claim? How much of a premium lift did the plaintiff get? And should we be concerned with that? Do we risk a form of cultural relativism, having to choose amongst religious cultural practices that either positively or negatively impact upon damage assessment? And if so, by how much? As I indicated, I want to address the issue of the extent to which common law doctrine, and in particular common law remedies, should take account of those cultural practices. Now, I use the term cultural practices without distinguishing between religious or other secular ethnic practices, although that is a distinction which is probably important, and we may come back to it. I asked to what extent do courts have an obligation to model the common law to accommodate Canada's commitment to multiculturalism. My concern is a practical and pragmatic approach. It's concerned with what should courts do when confronted with this type of claim. I'm going to frame my remark in 3 headings. The first part, I'm quickly going to set out sort of Canada's approach to multiculturalism. In the second part, I want to focus on 2 Supreme Court of Canada cases actually dealing with religious freedoms, but the way that they've approached them speak a lot about the or aspects of multiculturalism, and also how we're going to confront the common law approach to multiculturalism. And then thirdly, I'm going to deal with what a trial court judge should do, and I'll make an argument that we should distinguish between recognition of the claim itself and the levels of compensation that we should award with damages, in fact, whether we should award damages at all. Now, if we think about Canada's approach to multiculturalism, we take some pride in it as a country that's created a modern democracy able to accommodate a diverse range of ethnic communities without the strife that is often witnessed abroad. But we all don't agree on the commitment to multiculturalism or how it should be carried through into practice. I think it's possible to construct a sort of continuum of multiculturalism. At one end of that continuum, we would have what's known as a strong assimilation approach. And that strong assimilation approach would be characterised by 2 points. One, a strong state neutrality, that is, that government and its departments have no right to advance or support particular interests based on religious or ethnic grounds. And secondly, a strong adherence to an ever-expanding set of core values that define Canadian identity, including democratic participation, equality, the rule of law, healthcare, education, military, and if you go on to the Canada Heritage site, you'll see a new reverence for royalty on that website. Of course, the claim that this is a neutral position is obviously not accurate. What is meant by state neutrality here is simply that the dominant cultural group fashions the notion of Canadian identity in its own image and requires others to assimilate into it. And we perhaps saw examples of that approach in the most recent Quebec election. We see the Charter of Quebec Values as a sort of a particular view of what Quebec society was supposed to represent. At the other end, we would have complete separation, perhaps something loosely the sort of Swiss version, where separate cantons come together on a few aspects of common interests. In the middle, or somewhere along that continuum, we would have a notion of weak assimilation. And it's also characterised by sort of 2 points. The view that there is, again, state neutrality, but in this sense, the state cannot advance one religion or ethnic interest to the exclusion of others, but it can use state resources to advance the idea that there's value in multiculturalism and building citizenship. To use that modern language, there's legitimacy in the state acting as a choice architect to shape public opinion, public ideas. And secondly, a weak adherence to a smaller set of core values that define Canadian identity, certainly democratic participation, the rule of law, and perhaps equality, but fewer values than in strong assimilation. Now, how a court positions itself on this continuum, and what consequences flow from that choice when adjudicating on a particular case before the court is going to change depending on the judicial attitude to where they position themselves. I think you'll actually see in the 2 religious freedom cases I'm going to talk about shortly, there's the gap between the judges can be charted on that particular line, and what you do actually see is the sort of francophone civilian-trained judges tend to be more towards the strongest on this line, and the others to the sort of weaker assimilation line. Now, to answer the question then where a judge should position themselves on the continuum requires us to have an understanding of the context in which adjudication takes place regarding multiculturalism. We're all aware that Canada has a governmental policy on multiculturalism, and one of the chief influences and commentator and policy maker for Canada has been Professor William Kymlicka, a political philosopher at Queen's University, who was certainly very instrumental in the Liberal governments in framing the approach to multiculturalism. I want to pick up on 5 specific points that Kymlicka makes about the multiculturalism policy. The first point that Kymlicka states about multiculturalism is that it's part of a discourse on diversity politics. And in Canada, there are 3 forms of diverse citizenship with their own distinct set of problems, their own place in constitutional documents, and distinctive language used for that discourse. What Kymlicka talks about as being 3 silos. Aboriginal peoples, and there you tell the language of treaty rights, self-governance, and we have a demonstration of that approach just last weekend with the case of the child, the 11-year-old child who is going towards a holistic medicine approach to deal with her leukemia, and the court invokes the Aboriginal rights as a way to justify that rather than focus on best interests of the child. Secondly, francophone or Quebecois, and here we have the language used of distinct society, linguistic rights, and two founding nations. And then immigrants. Now, immigrants were initially recruited from countries that reflected the dominant English settler group in Canada, and beyond that, other white ethnic countries who were expected to quickly assimilate. Only later, when Canada adopted neutral admissions criteria on immigration and explicit policy on multiculturalism, did diverse ethnic identities come to Canada with an expectation that they could celebrate their ethnic distinctiveness. Here, the discourse uses terms such as multiculturalism, citizenship, integration, tolerance, diversity, and inclusion. Kymlicka argues that we have to recognise these distinctive silos and that there is no commonality in policy treatment. Diversity politics is like any other area in the political sphere. It's one to be managed through the use of a portfolio of policies. And one has to question, do courts have the same mechanisms when they are confronted with the judicial process? The second point that Kymlicka points out is that policies of multiculturalism were a product of the resurgent interest in human rights and liberalisation of society that took place in the 1970s and 1980s. And for Canada, no greater evidence of that resurgence is the adoption of the Charter. These policies of multiculturalism have been built on a liberal paradigm of individual human rights, private autonomy, and personal choice. Kymlicka states that we have to recognise two distinct aspects of the policies of multiculturalism regarding immigrants. One are the policies advanced to protect group rights against the demand of the majority culture, what he terms the demands for external protections. And two are the policy claims made by minority groups to impose restrictions on its own minority members to advance group cohesion, what he terms internal restrictions. So claims for minority language instruction or separate education would fall into the former, but cultural practices towards arranged marriages or withdrawal from schooling fall into the latter. In answer to the question, should liberal society, or how should liberal society deal with illiberal minority cultural practices, claims which more often fall into the category of internal restrictions, Kymlicka suggests that the liberal claim to individual autonomy must prevail, but that the nation state must be patient and cautious in coercing compliance. Kymlicka's third point is that it's not unjust to require of immigrant groups to assimilate into their new land rather than recreate their societal culture left behind. And by societal culture, he describes the environment in which an individual is able to engage across a full range of activities, including social, educational, religious, political, and economic life. All individuals, as an aspect of individual freedom, are entitled to engage meaningfully across the wide spectrum of activities encompassed within societal culture. However, an individual can waive that right by the act of free choice, and deciding to emigrate constitutes such a waiver. Thus, it's not illiberal to require of an immigrant to attain some level of official language proficiency so that they can meaningfully engage in the new societal culture of which they have chosen to be part. Of course, the children of immigrants do not exercise their same choice, but they then have the rights articulated above, the liberal claim to autonomy against attempts to coerce compliance to some minority group cultural practices. Now, as you'll notice, my accent is quite distinct, although if you've been taught by Craig Brown at any stage, there may be some passing familiarity. As my students say, that I speak, like the Prime Minister, neither official languages correctly. His fourth point is that on the road to multiculturalism, we often forget that the societal accommodation has not all been one way, minority yielding to the will of the dominant culture. In fact, dominant cultures have been required to give up many privileged positions. Their fantasies of racial superiority their exclusive ownership of the state, attempts to fashion organs of the state in their own Christian white images have all been given up. And his fifth point, we should not ignore the evidence that just as dominant cultures exhibit discrimination and prejudice, minority groups may harbour similar prejudice and practice discrimination against other groups. For Kymlicka, maintaining the fertile soil of our liberal democracy is hard work and requires constant cultivation. Now, Kymlicka's observations address public policy, and they speak at a level of group identity and generality. It provides context, but it's not determinative of any individual case before a court. So let us now turn to how courts, and in particular the Supreme Court of Canada, has dealt with multiculturalism and claims raising cultural practices. Now, we're all aware of section 27 of the Charter, and that states the Charter shall be interpreted in a manner consistent with the preservation and enhancement of the multicultural heritage of Canada. My colleague Bruce Elman has written on the history of that provision, and much could be said. However, I take his assessment and that of one of his former colleagues, Gerald Paul, to be accurate, namely that there has been a declining usage of resort to section 27 by courts, that it's often mentioned only in passing and not in any sense of deliberative engagement, and that it's often the argument of last resort to be mentioned by counsel. But as I say, there are two Supreme Court of Canada cases which I think we should consider, which provide instruction on the dealing with multiculturalism. The first case, and perhaps one familiar to upper year students certainly, and perhaps first year students shortly, is the Brooker and Markowitz case. Brooker and Markowitz, not a tort case, but is illustrative of the difficulty in deciding what to do with culture, here a religious issue, in common law damage assessment. It also illustrates divergence on where on the continuum of multiculturalism a judge stands, but that can have a dramatic impact on the result. Now, Stephanie Brooker and Jason Markowitz were both religious and observant Jews, married in 1969 and divorced in 1980. Part of the divorce settlement required Markowitz to give his former wife a get, a necessary formality to allow Brooker to be divorced according to Jewish religious custom. Without the get, Brooker was unable to remarry in accordance with Jewish law, although nothing impeded her ability to remarry in Canadian civil law. Brooker sought to enforce the agreement, not requesting specific enforcement, but claiming damages for breach of contract. Now, in fact, Markowitz had given the get some 15 years after the agreement. In the intervening time, Brooker had not remarried, nor had she given birth to any other children. In proceedings brought by Brooker, Markowitz claimed that an action to enforce the contract violated his freedom of religion. The trial judge held in Brooker's favour, awarding her $47,500 in damages, being $2,500 for each year the get had been refused, and another $10,000 for her inability to have children legitimately within Jewish law. For the majority, and the majority judgment was given by Justice Abella, two issues were raised by the appeal. One, whether in Quebec civil law there was a valid contract, and two, how should Markowitz's freedom of religion right under the Quebec Charter be evaluated? On the first question, the court saw no difficulty in determining that Markowitz had entered a civil as against a moral obligation to furnish the get. On the application of the Quebec Charter, this engaged the balance of freedom of religion against other significant public rights and interests. In this case, Justice Abella, for the majority, promptly challenged Markowitz's good faith and sincerity of religious belief as his reason for denying granting the get. However, conceding that point, she then went on to say that there were sound public policy reasons to enforce the get so as to enable Brooker to participate in her faith culture. She undertook a large review of what other jurisdictions do in these types of cases. She also went fully into changes in the Divorce Act which had been made to try and deal with this particular issue. The dissenting judgment given by Justice Deschamps and supported by Justice Charan is based upon a strong assertion of state neutrality concerning religious matters, and that courts may only consider questions of a religious nature where the claim is based on a violation of a rule recognised in positive law. In this case, the claim could not be based upon a contract because the obligation created between the parties lacked an object capable of juridical operation, both requirements under Quebec civil law for contractual liability. The object in this case was obtaining a religious divorce, which could only be given by rabbinical authorities, itself an act not recognised as having civil law consequences. At most, the object created by the contract gave rise to a duty upon conscience and thus rose to the level of a moral obligation, not a civil obligation. Now, both judgments use an appeal to multiculturalism to bolster their positions, although they don't specifically mention Section 27 of the Charter. And clearly underlying the position of the judges reflects a different conception of multiculturalism and the degree of accommodation required. Nevertheless, there is something in the minority's view that by giving a damages award, the majority is by necessity making an evaluation judgment on what it is, or what is the price to be paid on a religious cultural practice, and one that for the minority is inconsistent with the recognised freedom of Canadian women to remarry without their former husband's consent. In this case, before the trial court, the plaintiff had initially requested $500,000, later amended after the get had in fact been granted to $1.3 million. Neither party placed any precedent or guideline for calculating damages before the trial court, which simply exercised its discretion. The majority decision of the Supreme Court quickly skirts over this point, simply asserting that there was no reason to interfere with the trial judge's exercise of discretion in the case. Now, the majority judgment in Brooker states that it's applying the Supreme Court's earlier ruling in the Kymlicka, Northcrest and Absalom, as have all other subsequent Supreme Court of Canada cases which have raised freedom of religion. To quickly remind you, in Absalom, the plaintiff desired to build a private sukkah on his balcony to celebrate the Jewish festival of Sukkot. Such a structure was in contravention of the condominium's bylaws. The condominium board sought an injunction to enforce the bylaw, to which Mr. Absalom claimed that such an action constituted a violation of his freedom of religion as protected under the Quebec Charter. The court similarly dealt with this case as an exposition of the Canadian Charter, which has a similar provision. Now, Absalom is notable for its expansive definition it gives to freedom of religion. For our purposes, it's important to note how a claimant proves his or her religious practice and adherence. There are two aspects of proof associated with establishing freedom of religion. One, proof of the particular religious practice, and two, a person's sincerity in the practice's tenets. On the first issue, the majority only requires that the claimant show that his or her beliefs or practices, measured either objectively or subjectively, have a nexus with religion. This is the point of departure with the dissenting judgments, which would require that a person demonstrate a nexus with an objectively identified religious belief or practice, sufficient to enable a court to distinguish between genuine religious belief and personal choice or practices that are unrelated to freedom of conscience. The point of the majority's opinion was to avoid the spectre of having competing visions of religious observance put before the court and requiring the court to wade into areas of religious custom and practice, which had in fact happened in Absalom. There were competing rabbis giving evidence. On the second issue of proof, the majority required the applicant to demonstrate sincerity in his or her belief, defined as a belief that is held in good faith, neither fictitious nor capricious, and that is not artifice. However, the majority held that this should not be a rigorous inquiry and must respect the fluid nature of how religious belief may change over time. And nor was there need for expert evidence. The claimant should simply focus the inquiry upon the time of the actual claim to the violation of freedom and not to past practices. Now, applying Absalom into Brooker, we can see why the majority in Brooker raised questions about Markowitz's sincerity in claiming his refusal to get a get. And that was in a proper assertion of his freedom of religion. The Jewish faith did not require him to refuse the get. It only enabled him to do so. His motivation for refusing the get was seen by the court as an expression of his anger at his former wife for a variety of actions dealing with other aspects of the divorce and visitations with the children of the marriage. However, it's also interesting to note in Brooker that Mrs. Brooker's own religious observance had obviously been put into question before the trial court, presumably in an attempt to minimise the damages. Now, what strands can be drawn from these two cases? The first one, fairly self-evident, is that religious freedoms are often associated with cultural identity, and intrusions upon cultural identity affect a person's dignity. Secondly, that courts should be reluctant to require expert evidence of religious customs and practices. The subjective assertion by a claimant should be sufficient if held sincerely and in good faith. However, query whether secular cultural practices should be treated in the same way. The Supreme Court's judgment deals only with religious practices, where the protection accorded to religious freedoms are obviously stronger than secular cultural practices. Cultural practices are more fluid, subject to wide variation with culture, and observance changes more rapidly within generations. That alone may suggest a more orthodox approach to proof should be adopted. Thirdly, that courts require a claimant to demonstrate sincerity and good faith in their adherence to the religious practice they are asserting. However, this is not an onerous burden and can be met by evidence given by the claimant him or herself. Again, query whether the same applies to secular cultural practices. Fourthly, a final observation is to note that the damages in Brooker were modest, although not insignificant. One may ask why $47,500 and not the figure in the claim of $1.3 million or simply $1. The damages awarded are what in common law are regarded as damages for non-pecuniary loss. Now, I would suggest that the implication of these two Supreme Court encounter cases is that the level of scrutiny given to a person's claim, certainly of religious practices, is minimal, and it would be the same if cultural practices are absorbed into that analysis. And the court has indicated that where those practices are violated in the context of a civil dispute, then damages are warranted, but there's no guidance there on the level of compensation which should be granted. Let me turn now to my third hearing of pulling our strands together about our notion of multiculturalism and the Supreme Court's liberal interpretation of what constitutes religious practices. Now, at this stage, I imagine that a tort scholar, let me now jump into more my unfamiliar territory for me, but much more familiar for Jason. I imagine a tort scholar would approach this issue with a simple response, and that is that the defendant takes him or her victor how she finds him or her. If the victim has a religious or cultural practice and that's injured, then that alone justifies the levels of compensation. In that sense, one is assimilating religion and cultural practices, that they should be treated as something like an eggshell skull, just as Tort accommodates eggshell skull personalities. There's been a recent article by Olga Redko, a very informative article titled Religious Practice as a Thin Skull in the Context of Civil Liability. Now, Redko admits that positioning of religious practices within the full rigour of a thin skull shell doctrine is an uncomfortable fit. Eggshell skulls raise either pre-existing psychological or physiological conditions which are permanent and immutable. Religious and cultural practices are voluntarily assumed, observance constantly re-evaluated, and subject to wild variations in practice by the observer. It's an uncomfortable fit to say that they are permanent or immutable. A weaker expression of the thin-shell skull doctrine is one that's argued by Professor Vaughan Black from Dalhousie. He suggests that cultural practices should be seen like any other variable, like education, employment, history, family circumstances, physical health, etc., that impact upon personal injury damages. Black points out that in many of the cases in which a cultural claim is raised, the genus of the type of harm would be equally experienced by others, and the cultural factor only goes to augment the actual damages. Thus, in my earlier example, we may all experience embarrassment from facial disfigurement, albeit that it's more intensely felt by someone of Korean heritage. I would note, however, that in the Lee case, the plaintiff argued that it brought both embarrassment and shame to himself and his family. And I think shame and embarrassment invoke different emotions and therefore tap into different types of losses. Now, I have no objection to Black's approach and recognising claims based upon religious and cultural practices, certainly in the area of personal injuries. But having recognised the claim, we've both in fact argued that courts should insist upon better evidence to substantiate the claim. Up to now, the vast majority of these claims have simply relied upon the evidence provided by the plaintiff alone. Such evidence will also then come under greater scrutiny by defendants, as happened in Brooker, putting into question Mrs. Brooker's religious observance. But I'll come back to whether that is a desirable thing to be encouraged. Recognition of the claim also raises the spectre of defendants arguing independently that objectionable cultural practices can operate to depress damages, and that a defendant should be able to raise such matters. What sort of source for the goose is source for the gander argument. Perhaps we can return to that in the questions, but I'll leave that aside at the moment. Having recognised that cultural and religious practices can be claimed, and that they legitimately impact upon damages awards, still begs the question, what should be awarded? My earlier article, Black's article and Redco's articles, don't touch on that issue, and nor did the Supreme Court in Brooker. But ultimately, it is the practical question faced by lawyers, judges, and juries. A request for enhanced damages based upon some religious or cultural practice will usually fall into the non-pecuniary loss heading, or within the equivalent Family Law Act provisions on fatal accident claims. And here I believe a good case can be made for distinguishing between the recognition of the claim and attempts to quantify the claim's worth and damages. Recognition of the claim calls for sympathetic treatment by courts, as witnessed in Amsel. The full implications of that decision need to be worked out in the context of compensation of private actions. Without a degree of objectivity in asserting a religious practice and proof of sincerity in belief drawn at a very low level, the door is particularly wide open to make such claims. It'll be very wide open if a similar approach is applied to determine claims of secular cultural practices. Having drawn that wide net may lead us to exercise caution on the quantification of damages. Now, if the guiding principle for damages is compensation, then awarding or augmenting damages based upon cultural or religious practice as part of the non-pecuniary loss claim in personal injuries has to conform to the jurisprudence in that area, including a cap on those damages. It's difficult to see how these claims work within the functional approach adopted by the Supreme Court of Canada as applicable in personal injury jurisprudence. I've argued elsewhere that Canada does not in fact follow a functional approach, but applies a modified conceptual approach that links the award to an acceptable range of comparable awards across the country. Those comparisons tend to focus upon the significance of the degree of physical injury, as is similarly applied in workers' compensation schemes. And there's currently insufficient cases to identify comparators for religious and cultural claims. When these cases do emerge, it promises the spectre of invidious comparisons between how the different felt lives experienced by claimants' religious and cultural practices equate to one another. So we'll have this notion of a Korean's facial disfigurement causing shame as against another case of a woman who's of a Muslim faith but is sterilised, medical malpractice, and she argues that the inability to bear children adversely impacts upon her ability to have another relationship with or marry within her faith. So you'll have equations between these types of claims as to what they should be compensated at. Compensation also requires us to consider how exactly awarding damages compensates for the individual's loss and how the plaintiff actually experiences that loss. It's the issue of incommensurability that bedevils awards on non-pecuniary damages. Simply put, damages are a poor substitute for how a person feels. Or as one of the, and this will date me a lot, was one of the goons of the original Goon show, which was the forerunner of Spike Mulligan famously asserted, he said that money can't buy you happiness, but it buys you a better class of misery. In my early example, how does giving Mr. Lee money compensate or ameliorate his embarrassment and shame from having a disfigured face? Here we will need to take account of emerging research that is investigating how all forms of injury and stress impact upon feelings of happiness. What is emerging from that research is that the psychic body has remarkable recuperative capacity, and that declines in happiness about one's life as a result of injury or stress are more transient than permanent. It's a blossoming field of research for young colleagues or anybody who wants to get into it, is the psychology of happiness and what impact it has. There are some wonderful emerging longitudinal studies which tend to say that even the most catastrophic losses don't have lasting declines in people's feelings of happiness. If that research bears validity, it does have profound impacts upon how we go about quantifying non-pecuniary loss damages. We should also note that claims for personal injuries under other statutory schemes, such as workers' compensation and no-fault automobile insurance, ignore cultural or religious claims, preferring to base the award for non-pecuniary damages solely on the extent of the level of impairment experienced, and preferring to adopt the nomenclature of compensation, titling it as non-economic loss benefits. In other settings, particularly human rights, violations of religious freedoms are conceived as injury to a person's dignity. Because these rights are viewed as fundamental, there's one view that to make the infringed right commensurate with damages is in fact to seriously weaken the value attributable to that right. We regard these types of freedoms as being inalienable, and therefore we do a disservice by giving them a value in damages. On the other hand, Canadian courts have started to award damages for injury to a person's dignity, but the damages in those areas remain modest and amount to a conventional sum, one that is measured, proportionate, and consistent. And the purpose behind those awards is not to compensate, but is to vindicate. And that's evident in the Supreme Court of Canada's decision of Vancouver City and Ward. Now, I'm arguing for no or extremely modest damages where a religious or cultural claim is raised in the context of a personal injury suit. A practical implication for my approach is to discourage a claim from being pursued. Although it's a personal value judgment, I have to question what is gained from having an action brought in Brooker, particularly after the get had been granted. If Markovitz was still recalcitrant in honouring his agreement, it would have raised a much more difficult issue as to whether the court would have awarded specific enforcement of that agreement. And we shouldn't think that cultural claims arise solely in the tort or personal injury settings. If you've come across the case called Solus and Corconsolis, a constructive trust fiduciary case, the court justifies the granting of a constructive trust remedy in that case, partly on the grounds that in the Greek community, to be the landlord of one's banker is to bring much credit and personal worth. And that was one of the justifications for giving a proprietary remedy as against giving a damages remedy in that case. The case was not exclusively within the province of personal injuries. Even if modest damages do not deter the applicant, it may weaken the resolve of the defendant from contesting the claim. Evidence that challenges the claimant's sincerity and good faith observance can only fuel the flames of animosity between the parties. Engaging in this form of litigation tactic hardly seems conducive to advancing social harmony and multiculturalism. The fear that the Supreme Court had in Amsel and Brooker, that you'd have competing visions of rabbi evidence, we threaten again to have in the compensation of damages. If damages are modest, this doesn't have to mean the loss to the claimant is inconsequential. What it does suggest is that judicial acknowledgement of the harm, or an apology, even a coerced one, may be a more appropriate remedy. And again, there's a lot of interesting research being done on the notion of apology and what actual plaintiffs want from litigation. What my approach avoids is the spectre of cultural relativism. The level of damages awarded could not be used as an indicator of merit, worth, or value of the claimant's religious or cultural claims in the eyes of the law. I started my lecture with reference to governmental policy on multiculturalism, and I indicated that for governments, multiculturalism is an issue to be managed by a variety of policy tools. Courts don't have access to those same policy tools, but they are equally confronted with an issue to be managed. I have suggested that such claims should be recognised, but that the remedial response is attenuated. I hope that my comments have provided some guidance for how courts should adopt, or what courts should adopt and how they apply this approach. I thank you for your listening.